Thank you for joining the hearing. Before we begin, Mr. Riker.
Hi, good evening, Ms. Jennings. I was part of the original application. I was asked to recuse myself on that one. Therefore, I'm going to recuse myself on this one. Wish you and the applicant best of luck.
Thank you. And at this point, we'll turn the meeting over to Brent. Okay, yes. Thank you for tonight's application. We have block 23001, lots 22 through 29, Jackson Trails LLC. This is the Whispering Woods hearing. Good afternoon, everybody. I'm Brent.
Brent Coleman.
Here, I'll give you my card when we're done for spelling a name. Brent Pullman with the law firm of Mandelbaum Barrett. I'm our LUPA counsel. Our LUPA counsel for the Jackson Township. I was also counsel for the township in the underlying litigation relating to this application. We are here this evening for a Whispering Woods hearing. A Whispering Woods hearing is the name given to a hearing in which a land use board reviews a site plan or is presented with the changes to a site plan that resulted from the settlement of litigation arising from a denial. The board is not hearing the case for the purposes of granting relief or approval of plans. Rather, the board is adopting the terms of the settlement after the public has had the opportunity to hear the terms of the settlement and participate in this proceeding. The purpose of tonight is for the public. Our courts have told us that despite municipalities' authority to resolve litigation in order to comply with the municipal land use law, members of the public have to have the opportunity to be presented with, ask questions about, and comment upon settlements involving land use matters. I'm going to begin with what will be, will sound like some boring legalese. However, it is very important that we establish this on the record before proceeding. I am reading from a settlement agreement and consent order which resolved the litigation by and between Jackson Trails LLC, Jackson 222324 LLC, Jackson Farms LLC, Jackson Run LLC, Jackson Walk LLC, Lakewood Investments LLC, collectively referred to as the plaintiffs, and the planning board of the township of Jackson in Jackson Township. This settlement agreement was entered by the court and filed on March 31st, 2022. I will begin by reading Article 4, page 16. Whispering Woods hearing. Within 30 days of the expiration of the appeal period to challenge the ordinance adoption or certification of the ordinance by the Pinelands Commission, whichever last occurs, the planning board will convene a duly noticed meeting at which it will conduct a hearing to approve the final application in Schedule B, which shall provide for a total of 386 market rate units and 96 total affordable units, which shall be fully compliant with the RG3 zone as amended. At that same Whispering Woods hearing, the Township Planning Board shall consider and approve plaintiff's request for rear yard decks not to exceed 240 square feet in the rear setbacks, with stairs not to exceed 100 square feet for all or any of the market rate units. This meeting will be held to consider these matters in compliance with the requirements of Whispering Woods at Bayham Hollow versus Middletown Planning Board, 220 and J Super 161, Law Division 1987. Quote, this is the Whispering Woods hearing. No unrelated business will be included on the agenda for the meeting, which will consist only of a Whispering Woods hearing for purposes of considering the final application as depicted on Schedule B to this document. Defendant Planning Board shall provide any and all required notice under the Open Public Meeting Act and the Municipal Land Use Law for the Whispering Woods hearing. The subject Whispering Woods hearing will continue until completed, including final deliberations and a vote by the Planning Board. In no event shall the proceeding extend beyond one single Whispering Woods hearing. For the avoidance of doubt, the Planning Board's final deliberations and a vote on the final application as depicted on Schedule B must occur and the hearing must conclude within a course of a single Whispering Woods hearing at one meeting. Plaintiffs will provide notice of the Whispering Woods hearing at least 10 days prior to the date of the hearing by A, publication in a newspaper of general circulation in the township, B, certified mail to the owners of all real property located within 200 feet in all directions of the property as shown on the current tax map, and C, certified mail to any public utility company, cable television company, or local utility which possesses a right-of-way or easement within the township and is registered with the township in accordance with NJSA 40:55D-12.1. The following procedures will govern the Whispering Woods hearing. A, the planning board attorney will submit a copy of this agreement into evidence. I will be presenting this into evidence at the conclusion of giving my remarks. B, the plaintiff's engineer or planner will present a final application as depicted on Schedule B, and the planning board engineer or other designated representative witness will present testimony regarding the settlement agreement. C, no other live testimony will be presented or heard by the planning board except for testimony heard pursuant to paragraphs 4D through F below. D, the planning board shall provide all interested parties with the right through their attorneys, if represented, or directly if not represented, to cross-examine the witnesses identified above, subject to reasonable limitations as to the amount of time allowed for such cross-examination in accordance with NJSA 40:55D-10D.
Sorry, Corey, just slow that down.
40:55D-10D, which shall be as follows. For purposes of the Whispering Wood hearing and NJSA 40:55D-4, an interested party is defined as any person owning property within 200 feet of the property. Prior to being able to cross-examine witnesses, all interested parties shall identify themselves and provide under oath the address of the lot or lots they own within 200 feet of the property. All interested parties shall have 3 minutes to ask cross-examination questions per witness. This time limitation has been imposed to ensure that the hearing proceeds efficiently and in a timely manner while affording all interested parties the right to cross-examination witnesses. C, interested parties and residents of the township shall have the right to provide sworn comments on the final application during the hearing, provided that they identify themselves and their address prior to giving their testimony. Any interested party or resident of the township that fails to do so identify him or herself and their address will be precluded from speaking at the hearing. F, in accordance with NJSA 40:55D-10D, 5 minutes of sworn testimony per interested party or resident of the township shall be permitted. This time limitation has been imposed to ensure that the hearing proceeds efficiently and in a timely manner while affording all interested parties and residents of the township the right to provide the planning board with comments. G, at the conclusion of the Whispering Woods hearing or no later than 15 days thereafter, the planning board will adopt a resolution memorializing its decision in accordance with the rules and regulations and including all findings of fact and conclusions of law required under applicable law. In the event of an approval, the resolution shall only impose those conditions set forth in this agreement and or shown as final on the application as depicted on Schedule B, unless otherwise agreed in writing by the parties. I am now going to review the material terms of the settlement. These are set forth in Article 2 of the settlement agreement entered on March 31st, 2022. Land use terms. The parties agree that the plaintiff's proposed use of the property shall consist of 2 phases as described in this agreement. During the first phase, the plaintiff shall be permitted to use the property as depicted on Schedule A for residential housing consisting of 367 single-family homes, 92 multifamily units, a house of worship, and all related improvements. During the second phase and following the Whispering Woods hearing, described in paragraph 4 below, the parties agree that plaintiffs shall be permitted to use the property as depicted on the final application and Schedule B for residential housing consisting of 386 single-family homes, 96 multifamily units, a house of worship, and all related improvements. Schedule A and the final application as depicted on Schedule B shall collectively be referred to as the development. The parties further agree to comply with the following terms related to both phases of the development by plaintiffs. Upon execution of this settlement agreement, plaintiff shall not be required to obtain any additional relief from the township ordinances in order to construct and operate the development on the property in accordance with Schedule A and the land use terms contained herein. B, plaintiff shall submit Schedule A and the final application as depicted on Schedule B together with any and all required plans, reports, studies, etc. to the appropriate agencies if required, including but not limited to Jackson Township Municipal Utilities Authority, Manchester Township Utilities Department, New Jersey Department of Environmental Protection, Ocean County Planning Board, Ocean County Utilities Authority, Pinelands Commission, Jackson Township Bureau of Fire Prevention, Ocean County Soil Conservation District, and Ocean County Health Department. Upon receipt of approval by such agencies, plaintiff shall provide a copy of any permit or written evidence of approval to the planning board or its professionals. C, the township shall waive any and all building permit fees, including but not limited to building, fire, mechanical, electrical, plumbing, and other like fees paid to the township for the residential, market, and affordable units up to the amount of $1,500,000. There shall be a drawdown on this waiver amount as the units are constructed. The parties agree that this waiver does not include any permit fees due to the state of New Jersey Department of Community Affairs or any other state or county entity and the Jackson MUA, which the plaintiffs will assume. The township shall take all reasonable and necessary steps to expedite the review, approval, and or inspection of plaintiff's development so as not to delay the construction of plaintiff's development. Plaintiff shall have the exclusive right to install private wells in the development in lieu of a connection to the public water system. Plaintiffs will obtain a water allocation division or diversion permit if needed from the NJDEP. To ensure an expedited review process, the following conditions shall be imposed. Township Engineering Department will provide the engineer's cost estimate for purposes of bonding and the establishment of inspection escrows within 21 days after the submission of final plans as attached hereto as Schedule A. The Township Building Department and subcode official within 21 days of submittal of each building permit application will provide for the issuance of phased building permit for site work if there is site work permit required, footings and foundations and building shell permits, design, build, mechanical, electrical, and plumbing, street opening permits if required. If any of the above applications for said permits are deemed deficient, the township shall re-review within 5 days of submission of a corrected application. Timely response for requested inspections within 5 business days upon such request. If any inspections fail, the township shall re-inspect within 5 business days of plaintiff's request for same. In the event the township representatives fail 3 times or more to meet deadlines set forth in paragraph F, 2, and 3 above, the plaintiff shall be permitted to file for relief in court, including but not limited to a motion in aid of litigants' rights and request that the township pay attorney's fees and costs associated with said filing. G, if plaintiffs require any modifications to Schedule A on the final application as depicted on Schedule B, other than those modifications that are considered de minimis, i.e. field changes agreed to by the parties, plaintiffs shall submit a new development application to the appropriate municipal land use board pursuant to the municipal land use law, NJSA 40:55D-1. H, plaintiffs shall provide a statement from the Jackson Township tax collector that all taxes.
Sorry. Plaintiff shall provide a statement from the
Jackson Township tax collector that all taxes are paid in full as of the date of this settlement agreement. The township shall not be required to issue any permit in the event the taxes are delinquent for any portion of the development. Plaintiff shall submit an electronic file of Schedule A and Schedule B containing the entire site and lot layout. The plaintiffs shall ensure that all escrow fees for planning board professionals are current. In the event that any escrow fees are not current, then inspection shall not take place. Plaintiffs' materials, methods of construction, and details shall be in conformance with the engineering and building requirements of the Township of Jackson at the time of submission of the plaintiff's application, August 10th, 2018. Prior to the township releasing the Mylar map or maps for filing, plaintiffs shall furnish the township clerk with a cash bond and performance guarantee, an amount to be determined by the township engineer per phase. For example, the cash bond and performance guarantee based on the engineer's cost estimate for phase 1 shall be posted first with the other phases to follow. No permit shall be required to be issued unless or until a cash bond or performance guarantee has been deposited for that phase of any work to be performed in that phase. M, plaintiff shall post an inspection fee per phase with the township clerk in an amount to be determined by the township engineer pursuant to NJSA 40:55D-53. No inspection shall be required to be performed unless or until a cash bond or performance guarantee has been deposited for that phase for any work to be performed in that phase. N, the parties acknowledge that the development includes streets and stormwater detention basins. The township shall accept the dedication and maintenance of the same without further cost to plaintiffs. The defendant township specifically acknowledges that it is waiving the stormwater management maintenance fee required pursuant to ordinance 244-12K. O, the parties acknowledge that plaintiffs have provided drainage calculations confirming the on-site stormwater management system has been designed in accordance with the residential site improvement standards as represented by plaintiff's engineer during the public hearing applicable as of August 10th, 2018. Plaintiffs have provided the township with an operations and maintenance manual for the proper and efficient operation of the maintenance of all stormwater management systems pursuant to NJAC 7:8-5.8. Q, the parties agree that a homeowners association is not proposed or required for the single-family lots because the development does not include any common areas. Each single-family homeowner shall be responsible for the maintenance of their individual lots. However, plaintiffs or their successors in interest shall be responsible for the maintenance of the affordable housing parcel. The township shall be responsible for the maintenance of the streets and stormwater basins throughout the development. The developer shall accept responsibility and or set up a homeowners association to ensure the proper maintenance of the cisterns if the MUA and or the fire district will not accept responsibility for the same. If applicable, the HOA documents shall be reviewed and approved by the township attorney. R, plaintiffs shall enter into an agreement with the affordable housing liaison to implement the affordable housing component pursuant to the Uniform Housing Affordability Controls Regulations, NJAC 5:80-26.1. Plaintiffs shall set aside 20% of the housing units for affordable housing, 96 overall units. Affordable housing requirements. The developer shall satisfy the affordable housing obligations required in connection with the overall development by setting aside for very low, and moderate income households no fewer than 20% of all residential units developed as described herein, the affordable units. Because the entire development shall consist of 482 total residential units, combining market rate and affordable units, there shall be at least 96 affordable units. All the affordable units shall be non-age restricted family units, either rental or for sale, and shall fully comply with the Uniform Housing Affordability Controls, NJAC 5:80-26.1, with the sole exception that 13% of the affordable units within each bedroom distribution shall be required for very low income households earning 30% or less than the median income pursuant to the Fair Housing Act. NJSA 52:27D-301. Of the 96 affordable units, there shall be 66 three-bedroom units and 30 two-bedroom units. The income distribution of the affordable units shall be as follows. Of the 66 three-bedroom units, there shall be 9 very low-income units, 24 low-income units, and 33 moderate-income units. Of the 30 two-bedroom units, there shall be 4 very low-income units, 11 low-income units, and 15 moderate-income units. Construction of the affordable units shall be phased in compliance with NJAC 5:93-5.6D. Here, this means the following. The first 96 market rate units in phase 1 may be built before triggering a requirement under the COA regulations to construct any affordable units. However, in phase 2 of the development, the first 24 unit affordable housing building must be completed before the 97th certificate of occupancy is issued for a single family market rate unit. The phasing of the affordable units shall follow the phase summary table as depicted on Schedule B. The affordable unit shall be affirmatively marketed in accordance with UHAC and applicable law by an experienced administrative agent that's had at least 5 years of experience marketing affordable units in accordance with UHAC. The affirmative marketing shall include the community and regional organizations identified in the Mount Laurel Settlement Agreement between the Township of Jackson and the Fair Share Housing Center. And it shall also include posting of all affordable units on the New Jersey Housing Resource Center website. All the affordable units shall be subject to affordability controls of at least 30 years from the date of initial occupancy and affordable deed restrictions as provided for by UHAC, with the sole exception that very low income shall be defined as at or below 30% of median income pursuant to the Fair Housing Act, and the affordability controls shall remain unless and until the township takes action to extend or release the unit from such controls after at least 30 years in accordance with NJAC 5:80-26.11 and applicable law. The developer and any successors in interest, including any owner operator of the affordable units, shall be obligated to maintain and upgrade as may be needed the sewer and water infrastructure for the affordable units to ensure continued service and that it remains in good and workmanlike condition. No fee shall be charged to the residents of the affordable units, and the rents of the affordable units may not be increased for this. For example, if private water is provided for the affordable units, the developer shall be responsible for the maintenance and repair of the wells and pumps to provide water to the affordable units. The developer and any successors in interest, including any owner operator of the affordable units, shall also be obligated to construct the affordable housing in good and workmanlike condition and to maintain the units, keeping them up to code and otherwise in sound condition, consistent with the applicable building code requirements. No fee shall be charged to the residents of the affordable units, and the rents of the affordable units may not be increased for this. In the event the affordable units are sold by the developer to another developer or entity, the developer shall be obligated to inform the township in writing at least 30 days before the closing date of any such sale. As part of its obligation to inform the township prior to the closing date of any sale, the developer shall provide a certification and documentation evidencing the affordable units are properly deed restricted, administered, affirmatively marketed, and maintained in accordance with UHAC standards at the time of the sale, and that the prospective purchaser is aware and committed to the obligations to maintain and administer the units as affordable in accordance with UHAC standards following the sale. The parties agree that the development is not subject to any township soil ordinance, and that, if necessary, the NJDEP has jurisdiction over compliance issues concerning any fill brought to the property. The parties agree that the development is not subject to any further review by the Township Environmental Commission. The township shall act in good faith and support the plaintiff's efforts with regard to the plaintiff's application, submission, or request for reimbursement to the Jackson Municipal Utilities Authority. Plaintiff shall be exempt from the township's tree replacement ordinance, section 405-1 of the Township Code. In lieu of a tree placement monetary contribution, the plaintiff shall reforest the development consistent with sheet 111 as entitled Tree Location and Tree Save Plan of the site plan contained as part of Schedule A, since the vast majority of plaintiff's site is already vacant due to prior farming and pasture type uses. The parties agree that there shall be no further restriction on the development in the area near the CEA, and that market rate units may be constructed by plaintiffs near the CEA as depicted on Schedules A and B. Once that portion of the development receives a final RAO from the NJDEP, indicating that the plume area is clean. Pursuant to NJSA 40:55D-52E, the parties agree that the zoning requirements applicable to this property as depicted on the township zoning map shall not be changed for a period of 10 years after the date of this settlement agreement, except that the township can enact any amendments that do not reduce or otherwise limit the uses provided for in Schedules A, B, and D. The parties specifically agree that in no event shall any change or modification to the zoning requirements applicable to this property affect the terms of this settlement agreement. Plaintiff's site plan subdivision approval shall remain in full force and effect for 10 years from the date of the execution of this settlement agreement. Plaintiff shall be permitted to construct a front porch and steps on each single-family home within the front yard setback not to exceed 120 square feet as reflected on Schedule D attached to this agreement. Schedule D represents two examples of how provided to show the approximate size and configuration of said front porch and steps. Plaintiffs are not limited in any way to these two examples. This agreement incorporates any dimensional variance relief required with respect to same. Said front porch and steps built within the 120 square foot limitation may intrude into the front yard setback without each individual lot required to secure a bulk variance. The front yard setback shall be calculated from the front yard property line to the foundation of the principal structure of the single-family home. The plan as depicted on Schedule A has satisfied all conditions and is therefore resolution compliant. Plaintiffs agree that they shall provide screening for the rear of the property backing onto Basso Street, as was agreed by the plaintiffs at the first planning board hearing on this application in the form of a 6-foot-high vinyl privacy fence to be installed commencing with the start of Phase 2, with completion no later than the issuance of the last CO for Phase 3. Each individual lot with their rear yard contiguous to the rear yards of the properties fronting on Basso Street will contain a deed restriction requiring the future homeowner to maintain the 6-foot-high vinyl fence described in this paragraph. The purpose of this deed restriction is to provide privacy to the property owners fronting on Basso Street. That concludes the material terms of the settlement agreement. I now will ask the board's two professionals who are here this evening, Mr. Ernie Peters and Mr. Douglas Klee, if they have had an opportunity to review the settlement agreement, consent order, and schedules A, B, and D attached thereto. Have you?
Thank you, Brent. Yes, our office issued a report April 19th, 2023. And it would be my finding that the plans that are submitted are consistent with the settlement agreement. Two typos in my report on page 2 talks about a maximum of 4 dwelling units per building. That's actually 24. And there's also reference in my report regarding requirements for the multifamily development or multifamily development criteria, which is not really applicable to this site.
Mr. Peters, did you have the opportunity to review settlement agreement, the terms that as I articulated here this evening, as well as schedules A, B, and D?
Yes, I have, Mr. Pullman. Our office has a report dated April 19th, 2023, and I can confirm that the applicant is compliant not only with the settlement agreement, but the provisions of the RG3 Regional Growth Zone of the Jackson Township Land Use Ordinance.
Madam Board Secretary, I am moving the settlement agreement, which I have here, into evidence as Exhibit 1. I would ask direct that our professionals, we move each of their reports into the record as well. Which you have those, correct? Good evening, Ms. Jennings.
Good evening. For the record, I'm Don Jennings from the law firm Rollins, Goldman and Spitzer on behalf of the applicant. I have to say one thing. When we were drafting the settlement agreement, it seemed so much more exciting. But listening to you, Brent, not so much. I think I need to get a hobby. With that, I have with me to my left Ian Borden, and he's going to briefly address 3 issues with some exhibits. We wanted to talk about the differences between Schedule A and B, and then a little tweaking that we did on Schedule B, which was permitted by paragraph 2G, which permits minor modifications to the plan. And then we also wanted to talk about the water service to the site and touch on the status of the outside agency approvals very briefly.
Thank you. We'll swear in.
Please raise your right hand. You solemnly swear or affirm that the testimony, information, questions, or comments you present before the board will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Please state your name, spell your last, and your credentials, please.
Certainly. Good evening. Ian Borden, President, Professional Design Services, Airport Road in Lakewood, New Jersey. Professional planner licensed in the state of New Jersey. Been president of PDS for 18 years, worked in the field for nearly 40 years, graduate of Rutgers, and I've testified in front of this and many boards throughout the state.
Thank you. Board accepts your
Thank you.
credentials.
And if you could, Ian, just very briefly, I know you submitted a couple of exhibits to the board secretary prior to the meeting. And as I indicated, you're just going to go through to describe quickly what Schedule A and Schedule B actually are for the benefit of the public.
I will. I see. Thank you, Anthony. Schedule. This is the 3rd one, right? This is A3. The first sheet there, Anthony. There we go. Thank you. We marked it as A2, anticipating the settlement agreement marked as A1. And this is the Schedule A plan denoted in the settlement agreement, which contained 367 single-family residential lots and 92 affordable. The two areas I want to bring your attention to is the top right or the northern corner of the property. You have South Hope Chapel Road along the bottom. The Basso is above up here. And we have this last loop road under the Schedule A was the location of the original affordable housing units. Those were 92 units in a maximum of 4 units per building. That's what the ordinance said at the time that we made the application. And then the other area I want to direct your attention to is the area to the northern part, closer to South Hope Chapel. This loop, we had single family homes here. We also have the CEA noted in the agreement where we removed houses from within the CEA, which is located on the adjoining Earl property. If you don't mind, Anthony, go to A3, which is Schedule B. So this is the Schedule B that's attached to the agreement. And what occurred here is what was formerly the quad affordable housing units in the back here became single family market homes. And the affordable units were relocated closer to South Hope Chapel Road. And the intent was to have them in 24 unit buildings. The yield of this project becoming 386 single family residential lots and 96 affordable units. In the implementation, however, of this plan, most importantly, consulting with an architect, we developed a slight de minimis change to the affordable area, which is reflected in the plans actually submitted to the board, which is A4, the next exhibit. Which is the only change was made down in this affordable housing area. Still remains 96 units, still remains conforming parking. But what we did was we have one 24 unit building. Again, 24 unit buildings are permitted by the ordinance. The ordinance was adopted by the township as a result of the settlement agreement. But rather than 3 other 24 unit buildings, we have 6 12 unit buildings. And they're located rather than on one side of a very large parking area, they're located on either side of this parking area. So they're in the same location, same number of units, same conforming parking, but just what we believe to be a more attractive and more appropriate architectural style. So that was the de minimis change, but the effectively remained very consistent with the settlement as regarding the number of units, both affordable and market. There were no changes made through settlement B, nor this plan submitted settlement B to any of the roadway improvements along South Hope Chapel Road, the main access roads, the house of worship, the stormwater basins. All of those remain completely consistent with the Schedule A plans and Schedule B. As far as the water, I think the second item I was asked to testify to was the water. The project started as public water during the settlement discussion, as noted in the recitation. There is, we're allowed to do wells and cisterns in lieu of water. It is the applicant's intent and desire to do water. However, we continue to work with the MUA to do that, understanding that the location of this project requires the extension of water mains almost 3 miles in length, all the way from Whitesville Road to the project through to the project or to this township boundary, and then into Manchester Township, another almost a mile to connect to their system. We have been working with both Manchester and Jackson to accommodate that. There is developers agreements being discussed and negotiated, particularly with Jackson, to help mitigate the costs of those things. Should those things come to fruition, as we hope they will, we would provide public water to the site. The understanding, of course, though, however, there is that provision in the settlement about wells and cisterns, but we really hope not to do that. And then lastly, on the outside agencies, we had submitted an approval document to the board as part of this submittal, which includes all of the approvals. Schedule A has been fully approved by all regulatory agencies, including a no further review by Pinelands for phase 1. We understand that we need to amend those approvals as necessary for the Schedule B plan that is the subject of this hearing tonight, and those would be provided. Those amended approvals will be provided to your board professionals as part of any resolution compliance as denoted by the settlement agreement.
Thank you, Ian.
At this time, we would ask any interested party. An interested party is defined as an individual who resides or owns property within 200 feet of the development to come forward if they have any questions for the three professionals who are here this evening. The questions will be, the question and answer for each individual is limited to 3 minutes. They're seeing none. No. Yeah, it's not public session. This is, it's slightly different. So under this format, we have two different types of, and we don't need to close to move forward because now the second portion of the public's ability to participate is now any resident or property owner in the township of Jackson has the opportunity to come forward and make any comments regarding the subject matter of the testimony that you heard here this evening. There is a limit to a 5-minute participation period. Now.
Seeing no one come forward, I move to close the public session.
Roll call, please.
Mr. Bressing,
Yes.
Mr. Bernstein,
Yes.
Mr. Fleming,
Yeah.
Mr. Sullivan,
Yes.
Mr. Marzo. Yes. Mr. Heller, Mr. Wall, Mr. Herman.
Yes.
Okay, members of the board. Now would be if the matter, the purpose of this evening is to educate the public and provide them with the opportunity to ask questions, make comments on the settlement site plan. We have presented the site plan and changes to the public. The public has heard that the site plan conforms with the terms of the settlement. The record of this evening consists of the settlement agreement and consent order, the reports that were provided and as amended by the board's professionals, as well as the testimony offered by Mr. Borden. I would now present that it would be appropriate for the board to move on the final approval.
Mr. Chairman, I'd like to make a motion as in the original application to approve.
Second.
Roll call, please.
Mr. Bressing,
Yes.
Mr. Bernstein,
Yes.
Mr. Fleming,
Yeah.
Mr. Sullivan,
Yes.
Mr. Marzo. Yes. Mr. Heller, Mr. Wall,
Yes.
Mr. Herman.
Yes. Thank you.
Thank you very much.
Anyone like to make motions to close? I'd like to make a motion to close.
Second.
All in favor?
Aye.
Thank you.